Welcome to this edition of Real World Employment Law, where we talk about real cases that impact companies and their workplaces. We're coming to you today from BL Media Group's beautiful podcast studio here in Tysons. I'm Berenzweig Leonard. I'm both a managing partner at Berenzweig Leonard, as well as I head up the employment law practice here.
And hi, everyone. My name is Nick Johnson. I'm a partner here at Berenzweig Leonard, and I also work with Declan in our firm's employment practice.
And if Nick seems a little bit off today, it's because he's still reeling from the Clemson loss. You went to the game, didn't you?
I did go to the game. I did go to the game. And you know what? Just like Clemson will be back next year, I'm happy to be here and back for another installment of our Real World Employment Law.
Excellent, excellent. And it actually seemed like a really great game, so it seemed like that would be a fun experience. So today we're going to be talking about employees complaining in the workplace about things that they don't like in the workplace. So, for instance, they work too long hours. They're not getting paid enough. Employees are allowed in the United States, all private employers are allowed to criticize their company. They're allowed to complain within the workplace.
That's exactly right. Yeah. And what I find interesting is that, you know, that protection comes by way of the National Labor Relations Act. And when I talk to clients a lot, I mention that, and they say, no, that doesn't apply to me. I'm not a union-based company. But what's interesting is Section 7, which is what we're going to be talking about today, specifically applies to both union and non-union workplaces.
And what's interesting also, Nick, is the National Labor Relations Board, which, you know, where the National Labor Relations Act is administered, that's a political organization in essence. I mean, each administration fields the National Labor Relations Board with its majority of voters, so its majority of participants, and so therefore you kind of see changes as a new administration comes in, and we've seen that over the years.
That's exactly right. I think with this past administration, there was a lot of activity, and I think, you know, some of it can be political, but I think a lot of it also had to do with just the modernization of the workforce. You know, when this law was initially passed, it was passed in the 1930s, and, you know, employees talking about conditions of the workplace was a lot different back then than it is today. I mean, with the advent of social media, people have many different forums and means to kind of communicate, and you see a lot of litigation about things that just were non-existent when this law was first passed.
Yeah, and so the things that we're going to be talking about today, in particular the one case that we're going to be talking about, we're not saying, nobody's saying that employees are not able to voice their concerns about what they call their terms and conditions of employment. We're basically looking at how far they can go in the way they do so.
That's exactly right. That's exactly right. And if we want to kind of get into this recent case,
yeah, let's talk about it. Yeah.
There was a case that's gotten a good amount of media attention recently, and it was out of the D.C. Circuit. And so, in that case, there was a company that changed its policy as employees could sign up for overtime.
Okay, and companies do this all the time. They change their policies from time to time, and change is never easy, particularly in the workplace.
That's right, and this particular change involved employees using a sign-up sheet to volunteer for overtime, and it was actually a literal sign-up sheet that would be posted in kind of a space that was visible to all employees, and employees on their own could go up and sign up for overtime. Well, there were a handful of employees that were not particularly happy with this new policy. And there was one employee in particular that voiced his displeasure by actually going to the sign-up sheet and writing the literal words "whore board" on the sign-up sheet. And this was something that was completely visible to all other employees. And he wrote those words, and it was kind of something that was a part of the workforce. Well, the company, obviously, they eventually found out about this, and they eventually found out who was the person behind this.
And this is, by the way, just visible for all to see, males, females alike in the workplace?
Visible for all employees, males, females, all employees. And so the company, once they found out about this, they took action. And they took action in the form of terminating this employee. And what's important is they terminated the employee not only because this individual was defacing company property, but they viewed his conduct as harassing, specifically because it was visible to other employees. This was harassing behavior, and they had a zero-tolerance policy in the workforce.
Well, yeah, I mean, you have Title VII that, you know, if you were to call somebody in the workplace a whore, and forgive me for saying this, but this is what's at issue in this case. If you were to call somebody a whore in the workplace, I mean, I think courts would have trouble with that and say this is a hostile work environment. So I could see what the company was dealing with here.
That's right, and you would think that would be the case. Well, the employee took issue with his termination, and he filed a lawsuit, and he filed a lawsuit claiming that he was engaged in protected concerted activity when he wrote those offensive words on the sign-up sheet. And specifically, he was claiming that he was voicing his displeasure with this new overtime policy, a condition of the workforce.
And to be clear, there's no problem with voicing displeasure with overtime policies or anything like that, right?
That's exactly right. There are ways that you can voice your displeasure. There are means in which you can kind of raise complaints about wages, other conditions of the workforce. But here, it's not that was the problem with the company. The company said, you know what, you can voice your displeasure about this overtime policy. It's the manner in which you did it, which we view as harassing.
Okay.
Well,
so real-world employment law, we always ask the magic two-word question: who won, the company or the employee?
Well, surprisingly, when the lawsuit was initially brought before the NLRB, the employee won. So this individual who wrote those offensive words on the sign-up sheet was reinstated, and he won his lawsuit before the National Labor Relations Board.
So this federal agency, and this would have been under the prior administration, right?
That's correct.
This federal agency basically said, we know that this person wrote whoreboard where all could see it. We want him back in the workplace?
That's right. They said that that was protected concerted activity, and he was engaged in protected concerted activity, and because you terminated him because of that, it violated Section 7, and we're therefore going to reinstate him.
Wow. End of the story?
Well, actually, no, it's not the end of the story, and this is where it kind of picks back up. So the D.C. Circuit, the federal appellate court just outside of our office, they recently took this case up on appeal, and they just came down with a ruling yesterday that went against the NLRB. And they basically said that the NLRB, they got it wrong. And they said that the NLRB got it wrong because they did not take into consideration the fact that the company was trying to protect the workforce from harassment. And they said, you know what, this needs to go back to the NLRB for them to try and get this right.
It sounds like they took the position that there are competing interests. You can complain about things, but if you do so in such a manner that you actually create a new problem in the workplace, in this case, potentially creating a hostile work environment by publicizing words like whore in the workplace, it sounds like they said, we've got to compete, we've got competing interests, and we just can't let employees say whatever they want, even if they are complaining about workplace issues.
That's exactly right. And the D.C. Circuit said that the NLRB, when they were considering this issue, that they ignored the company's obligation under the federal anti-discrimination and anti-harassment laws to promote a safe and anti-harassing workplace.
Yeah. So there were a number of these cases that came out, let's just say in the last decade, that we've read about. They've made headlines in the news. There's one in particular. It's called the Pier 60 case, and I'll sort of abbreviate some of the profanity, but it was an employee who was mad at his supervisor for whatever reason. I mean, there was something going on in the workplace, and he said he was on a break from his work. He went on Facebook and he said, Bob is such a nasty mother effer, don't know how to talk to people. F his mother and his entire effing family, what a loser. And at the very end of it, he said, vote yes for union. So after this tirade of F-bombs, he then says, vote yes for union. And this was a case that wound its way in the last decade.
And what happened before the NLRB under the prior administration with that case?
What happened was they said because he tagged on at the end of it, vote yes for union, the rest of it sort of was protected speech. He was basically expressing his frustration. So he was allowed back and reinstated into the workplace.
And so where do things stand now? They're kind of revisiting that? Or?
So what happened was in December of this past year, 2019, so just roughly a month ago, the National Labor Relations Board under the new administration is basically taking a look at a lot of these old cases that made headlines where there were profanity-laced tirades by workers in the workplace. And they're basically saying, we need to take another look at this because we need to somehow create some kind of a balance between how far off somebody can go in the workplace with profanity and protecting all the other employees who have to actually listen and be exposed to this.
Wow, interesting. So if you're a company, I mean, what are you supposed to do in light of this changing landscape? I mean, it seems like, you know, under the prior administration, we had some rulings that are now being revisited. I mean, if you're a company, if you're a business owner, what should they be doing in light of these decisions?
Yeah, so now 2020, I believe, will be a year of more clarity in terms of how far, where's the line going to be drawn with respect to what employees can do in the workplace. Our advice to our business clients is, listen, you have to look at this on a case-by-case basis. If somebody says, you know, the F word out of frustration when complaining about something, I don't think we have a single, you know, type profanity that just says you should be fired for that. So I think they really do have to look at the totality of the circumstances. But I think what this is saying is, look, we don't have to put up with so much stuff. We don't have to put up with personal attacks against both the supervisor's mother in the case of the Pier 60 case. We no longer, it looks like the NLRB is basically saying, you no longer are going to have to put up with that. Now, we don't have that definite statement right now, but I think 2020 is where things are going with that.
Great discussion today, Declan, on a very important topic.
Yeah, no, I agree. And thanks, everyone, for joining us for this edition of the Real World Employment Law. And please, we hope you find this useful, and stay tuned for the next edition.